why everyone comes to creations day. Parliament versus Supreme Court. There's no try. Ghana. Country home. Speaker of Parliament, you will declare say seat view of Parliament, you declare vacant. Because those MPs now switch status. Yeah, you have video description I say. And Supreme Court, after Markins, that is majority parliament, majority leader in Parliament, the court. And a court say, "What boss assembly speaker cannot work." We halted that decision. In the unfast says it in back. Up till now, the Speaker of Parliament, NA. Now after Speaker decision, MPs need this idea say, go to Parliament because NDC folk far on the side of the Parliament, which is the majority side of Parliament, because we feel say they are not the majority. And because of that, and the number of people in Parliament in the city about from the speakers are there. You to me running the Parliament with those few MPs in the why join the Parliament indefinitely will be any do baby. After that decision, the same NPP MPs that boycotted Parliament, after comma speaker say, only be Parliament back. They are requesting. In fact, it is the Constitution says yeah to Parliament indefinitely. Like you can request the speaker to come. At 15% of the MPs, the whole MPs can request the speaker number back. Up to now, 7 days now Constitution they cancel after that requesting. There was a speaker be in a term. Speaker may now next speaker on reply. Supreme Court's ruling no on reply. He had to reply, no reply, now replying any letter they come Supreme Court saying the room. I say I'm directed by Right Honorable Aban Sumana Kingsford Bagbin, Speaker of Parliament, to return the attached processes which was left at the Legal Services Office of the Parliamentary Service by 3 bailiffs of the court on Wednesday, 16th October 2024. Attempts were made to serve the same process on Tuesday, 15th October 2024. The Right Honorable Speaker noted that the attempted service is contrary to Article 117 of the 1992 Constitution and the circular issued by Her Ladyship Justice Sarah Pamela Granting, the Judicial Service Secretary, and copied to the Honorable Lady Chief Justice with reference number SCR9 entitled Enforcement of Articles 117 and 118 Constitution. Immunity from service of process and arrest. The Article 117 of the 1992 Constitution states you cannot serve the speaker a letter, even a member of Parliament. Whilst a local Parliament, all Parliament and no free Parliament, no, you can't do that. That's what the Constitution says. And the speaker is saying, that service now, the brain will say, or mabo, or no decision, I think he said, or declare for seat vacant, no about to go. It has no hold water. It is contrary to the 1992 Constitution. Until you make it, or sure, let any be here, they can, what they know, the buy, no, so I could go Supreme Court. It's a Supreme Court for or money no more them. This time the lawyers can or Mukakushi or Mokoto. Now Supreme Court at Tanasem so. No mundi ruling aba or Musemasa on own sem now cano and fuck him. In the young court, name could the ruling of the Supreme Court. Ghana country well in more than Bibia. Hey, let's go and listen to the video at the time that the Chief Justice was making the ruling.
This is the ruling of the court. The Speaker of Parliament, as first defendant in this suit and applicant in this application, is praying this court for an order setting aside the processes and proceedings of the plaintiff's suit filed on 15th October 2024 and vacating an order made by this court on 18th October 2024. On 18th October 2024, this court heard an application for stay of execution of a ruling of the applicant declaring 4 seats in Parliament vacant on 17th October 2024. The application urged that the effect of this ruling is that the said members of Parliament for the 4 constituencies in Western, Eastern, Central, and Ashanti regions were declared to have vacated their seats by the Speaker of Parliament. And if the Speaker's ruling is enforced, the affected members of Parliament would have had to leave Parliament and all their duties and responsibilities entrusted to them by reason of their being members of Parliament from the 18th October 2024.
So what the Chief Justice is saying is that, in fact, the first ruling was the TISA, say, say, declare sitting vacant, it means that they're consistent in this one, so on boycotting, and even the MPs themselves, it is going to affect them because they will have to leave office and they won't get paid near the other. But the Constitution, what are we doing about that thing that our Constitution? We say once you switch status from political party to independence, independent candidate, what vacate you seat, then the air found. What time is that thing going to be applicable? Or say Supreme Court bench him?
These members of Parliament are namely Honorable Cynthia Mamle Morrison, Member of Parliament for Aguna West constituency in the Central Region, Honorable Andrew Esiama Amaku, MP for Fomena constituency in the Ashanti region, Honorable Kwadwo Asante, Member of Parliament for Suhum constituency in the Eastern region, and Honorable Peter Yaukwachi Aka, Member of Parliament for Amenfi Central in the Western region. 8 grounds have been presented to us in today's application. The submissions made in support of them can be summarized as follows. 1. That the Constitution and laws of Ghana provide no grounds to allow the actions of the Speaker of Parliament while presiding over Parliament to be questioned in any court, including the Supreme Court, because of the doctrine of separation of powers that guides Ghana's constitutional democracy. 2. That because of a circular issued by the Chief Justice of Ghana in 2021 and repeated by another circular issued by the current Chief Justice under the hand of the Judicial Secretary, the service of the processes in this suit on the Speaker of Parliament was invalid. As such, the Speaker of Parliament, under the hand of the Clerk of Parliament, had returned processes served. That whenever there is a vacation of parliamentary seat, and this is identified by Parliament in its proceedings, the only lawful forum for disputing any issue concerning the vacation of seat is the High Court, as provided for in Article 99 of the 1992 Constitution.
So what the Speaker is saying is that Article 99 says, say he declares it to be of Parliament vacant. You can only send it to the High Court, not the Supreme Court. But interesting though. The High Court decision, Supreme Court has it. What kind of constitution are we having? Hey, Ghana. Anyway, and again, the Article 117 of the Constitution says you cannot serve the Speaker a service from court or arrest him or even a member of Parliament whilst he's leaving Parliament, whilst he's going to Parliament, or whilst he's in Parliament. And some of the Speaker all canon. The then court and the back found. Medical grade will hear, so this is an old video. Medical will hear about to in the NTA.
After hearing only one party in the suit, and without hearing the Speaker of Parliament, the orders breached the rules of natural justice, breached the rules for exercising discretion provided for under Article 296 of the 1992 Constitution, and were invalid. 5. The orders of 18th October 2024 were made on the basis of fraudulent misrepresentations by the applicant to the court.
So the Speaker is also saying, say, Emra normal case there assembly court. Yeah, I'm free Speaker, man, I'm inside of the story. And one say the Supreme Court make a judgment. But the interesting thing is, it was an ex-party application. You got the ex-party application now. The kind of application I'll be to make you a court. And when he has a very dependent, the court can make a judgment. There is a restraining order. And there is a bill on ma na ebia bibi ba program bi ba because no be court say the court should put or restrain the program from happening. And he has a very the other party. And I say I'm a letter service say want to me organize the program, something like that. I don't think so on that aspect, the speaker is getting this right. The speaker is a lawyer, so I suppose anyway, and
6. The substantive action is incompetent because the writ was accompanied by a statement of claim and without an affidavit or verification. The application is opposed by the plaintiff, who is himself a member of parliament, and the Attorney General, who is a second defendant. We have considered the application.
By the first defendant.
Sorry, it's opposed by the first defendant. Sorry.
The application is opposed by the plaintiff.
By the plaintiff. Yeah. Aren't we tired?
She made a mistake, you'll be correcting the aren't we tired? Wabre. LGBT can want some that will court that are the munshim. Wait here, quickly, you people have time. Ghana is an interesting country. Anyway, it was.
We have considered the application and find that the grounds supporting the application have no merit because of the very explicit and clear directions of the 1992 Constitution, specifically Article 2, Article 130, and Article 296, and established decisions of the Supreme Court from decades of the country's constitutional history.
Into the all can say any merit be a when I cast idea and I just say about to into all force Supreme Court say on far to sit. Now in the process, the proceedings of course of court, there was a part the Chief Justice was complaining on why speakers, MPs are not meeting, are not sitting. On the speaker are joining parliament indefinitely. She was complaining. And Obi say, Mami, and our Chief Justice, we are here, the suit is about vacation of seats in parliament. Or we that's all back around from her. Why are you talking about, or more meetings or money? It's not about meetings with every video. So this is the video.
This is a constitutional crisis. We are living in a country where the parliament is not sitting. What is going on?
I'm not too sure that this suit is to enable parliament sit. It's to declare.
Very well. Yes, I take it. That's really in
yes. The video, no. Ghana. What do you think? Or the man is squarely lawyer. I think Bagbin the lawyers maybe. Yes, and to awesome. Now Ghana need a interesting country. Ghana, Ghana. So they are fighting over this. And I say I know my Fiji. Baby I did you will be a funny currency. And same be say no who ya and bufu ya or ya na at the crony menka. In the yes. Sa na ekos wo Ghana han Supreme Court asabo Speaker Bagbin in some the court down mun was about to say and utie video no kwa chira va the video no Ghana we post on their YouTube channel utie kwa chira. What the Supreme Court is also saying is that the article 2 of the 1922 Constitution states so be satisfied with anything in the country, you can send to the Supreme Court anywhere in the country, including Parliament House. So, one side of the Constitution says nobody can question Parliament. Then one side says Supreme Court, anybody can send anybody to Supreme Court. It is an interesting country. Anyway, and also, what do you think? Fatal comment section, I say. In the side of the it is never ending. Supreme Court versus Speaker Bagbin. Now, be Parliament in the Bimana and that one I doubt it will never happen because NDC is not ready to accept their, MPP is not ready to accept their minority status, and then I don't think the Speaker is also ready to bring those 4 seats back. Anyway, according to Speaker, it is a crime. I mean, according to the Supreme Court, it is a crime. Look at full video now. It is a crime. So be a for Supreme Court order including the Speaker and even the President and the Vice President. So, so maybe in the back, and also maybe in the back. But again, lawyer and us no kind. This suit wasn't about them meeting again or not meeting again. That is solely between parliamentarians. So the Supreme Court has nothing to do with that one. Yes, channel needing a cost two Christians. Unlike a video where now I like it, now I share mommy. Yes, subscribe to the channel for me. Send the bell information be say about on Sabbath Maka. You be sharing.